Meeting of the Senate Judiciary Committee will come to order. My apologies to all those in attendance. I'm sorry I'm late. Senator Grassley has warned me that he's going to dock my pay if I'm late, so I will accept the consequences.
It's going to hit you hard today.
It should. I'm going to waive my opening statement here, and
I'll waive mine too.
thank you very much. So let's go to our guest, who we're going to introduce some of our nominees. I think, Bob, Senator Menendez, you rank in seniority, so take it away.
Well, thank you, Mr. Chairman, Mr. Ranking Member, members of the committee. Today I have the great pleasure of introducing to you an outstanding nominee to the U.S. District Court for the District of New Jersey, Ms. Evelyn Padilla. Ms. Padilla is the immediate past president of the New Jersey State Bar Association. She was the first Puerto Rican and the first Latina woman to serve in this role, paving the way for future generations of Latinas in New Jersey. She is also the founder and senior managing partner of the law offices of Evelyn Padilla, where she has practiced family law and civil litigation since 1994. She also previously served as a municipal court judge for the city of Jersey City, as an in-house counsel for the Office of Landlord-Tenant Relations for that city as well. Outside of her extensive litigation practice, Ms. Padilla is very active in both county and state bar associations. She currently serves as a trustee of the Hudson County Bar Association of New Jersey. She sits on several New Jersey State Bar Association committees, including the Judicial and Prosecutorial Advisory Committee, the Nominating Committee, and the recently formed Diversity and Inclusion Task Force. She is also a former trustee of the Hispanic Bar Association of New Jersey and served on the board of New Jersey Women Lawyers. Born and raised in Jersey City, Ms. Padilla has always been committed to giving back to her community. As the founder and vice president of the Caravel Foundation, she has dedicated her efforts to enriching the lives of underrepresented communities by supporting initiatives in the arts, education, youth development, health, and human services. Additionally, she is a founding member of the Justice Virginia Law Family Inn of Court, an organization of legal professionals working to improve the professional and ethical quality of family law practice in New Jersey and across the country. So it is no surprise that Ms. Padilla is highly regarded in the legal community. In 2020, Ms. Padilla was named the New Jersey State Bar Association's Professional Attorney of the Year. In 2019, she received the Rutgers Law School Camden Latina Trailblazer Award, as well as the Hispanic Bar Association of New Jersey's Trailblazer Award. Simply put, she is a trailblazer with an indisputable depth of legal experience and a commitment to equal justice under the law for all Americans. I'm confident that Ms. Padilla's intellect, her temperament, her respect for precedents, her astute judgment, integrity, and impressive experience in the field of law will allow her to excel as a federal district court judge for the District of New Jersey. I'm proud to have recommended her appointment to the President, and I'm certain she will serve all the people of New Jersey well. I urge the committee to support her nomination, and certainly thank you for your consideration.
Thank you, Senator Menendez. Again, I'm sorry to have held you up this morning. Senator Casey?
Chairman Durbin, thank you for this opportunity. I want to thank you and the ranking member for the opportunity to appear before the committee. I'm proud this morning to introduce to the committee Ariana Freeman, who's been nominated to serve on the United States Court of Appeals for the Third Circuit. I want to thank Ariana for her willingness to serve, her commitment to public service, and of course her family's support and that of her friends for this nomination. Like all senators, when I make a determination about whether I should support a candidate for a federal judgeship, either the district court or the appellate court, I consider a variety of attributes, factors, qualities, including a person's academic record, their intellect, their integrity, and of course their commitment to equal justice and their commitment to judicial independence. Ariana Freeman embodies all of these attributes in abundance. After graduating from Swarthmore College and Yale Law School, Ariana started her legal career in the Eastern District of Pennsylvania by completing 2 clerkships for 2 district court judges, District Court Judge James T. Giles and C. Darnell Jones. In 2009, she began work with the Federal Community Defender Office in the Eastern District and quickly became a nationally recognized expert in habeas corpus litigation. She has litigated numerous cases in the Eastern District, and most importantly for today's hearing, she has been a lead or co-counsel in 28 appeals in the Court of Appeals for the Third Circuit, including 7 oral arguments. Her appellate reputation in the Third Circuit bar is so well known that her nomination has garnered very strong support, even beyond the Commonwealth of Pennsylvania, as evidenced by many letters of support submitted to the committee by former prosecutors, judges, law school deans, professors, and other distinguished members of the legal community. In one of those letters, Judge Giles, who served honorably on the district court for 29 years, wrote that Ariana was, quote, discerning and open-minded, unquote, and he highlighted her sense of fairness and dedication to the principles of equal justice for all. This reputation for fairness and open-mindedness is further reflected by her support in the prosecutor community. While Ariana Freeman served the majority of her career as a public defender, over 20 former prosecutors signed letters of support for her nomination, with one group writing the following, and I'm quoting, "Each of us has spent collectively several decades as public servants, profoundly understand the importance of a representative system of justice, and Ariana Freeman's background, including her deep-rooted perspective on the importance of impartiality in our criminal justice system, will add a needed perspective on the bench," unquote. There is no doubt that Ariana Freeman's extensive legal experience, keen intellect, combined with her deep commitment to the community and commitment to the principles of fairness and equal justice, will serve the Third Circuit well. Her nomination, in addition, is historic for Pennsylvania and for the entire Third Circuit Court of Appeals. If confirmed, Ariana Freeman will become the first woman of color to serve on the Third Circuit. Mr. Chairman, thank you for this opportunity to present her credentials and support her nomination strongly.
Thanks, Senator Casey. Of course, to my colleagues, if you need to be off on another assignment, we all have important work to do, and we appreciate your personal attendance this morning, as I'm sure the persons that you're speaking for will appreciate as well. Senator Gillibrand, we have Senator Peters and Senator Padilla in the wings. You've waited patiently, and I want to give you a chance to make a statement.
Thank you so much, Mr. Chairman. Thank you, Ranking Member Grassley, as well, and the members of the committee. I appreciate this opportunity. It's my honor and privilege to introduce Jennifer Reardon, nominee for the United States District Court for the Southern District of New York. I was proud to recommend her to the President, and I hope she will receive a swift confirmation. Ms. Reardon's legal knowledge, proven analytical skills, and temperament make her extremely qualified to serve as a district court judge. For the last 15 years, Ms. Reardon has served as a partner at Gibson Dunn in New York, where she gained experience and expertise that she will bring to the federal bench. Specifically, about half her legal work has been in federal court, primarily in the Southern District of New York, so she will bring a deep knowledge of the court's workings to the job on day one. She will also bring expertise in a range of issues and areas to the bench, having represented clients in a variety of complex matters, including cases involving fraud, contract, and environmental issues under CERCLA. As Michael Gerard, founder of the Sabin Center for Climate Change Law at Columbia Law School, who has worked with Ms. Reardon on a number of environmental matters, wrote to the committee, quote, "She has the analytical skills and the calm, steady demeanor that one hopes for in a judge." She is also praised for her thoughtful and fair approach to the law. Jeffrey Gracer, the former chair of the Environmental Law Committee of the New York City Bar Association and co-founder, president, and chair of the New York City Climate Action Alliance, wrote that Ms. Reardon, quote, "made a point of seeking out different points of view before she reached a conclusion," end of quote. While working at Gibson Dunn, Ms. Reardon also made sure to give back to her community by taking numerous pro bono cases. In one case, Ms. Reardon represented a domestic caregiver in a lawsuit against her employer for assault, battery, and unpaid overtime. According to the executive director of the Urban Justice Center, who referred the case to her, quote, "Ms. Reardon's hard work and dedication in protecting the rights of domestic workers demonstrates her belief in seeking justice for all," end of quote. In another pro bono case, Ms. Reardon represented an LGBTQ client in connection with his spousal death benefits claim after his Vermont civil union spouse died. Her commitment to others has also been made clear by the firm by the time she has spent serving as a mentor for young attorneys and working to recruit diverse candidates to the legal profession. Ms. Reardon's academic credentials are so impressive as her professional ones. She received her JD from NYU School of Law, where she was an editor of the Journal of International Law and Politics. She graduated magna cum laude from Yale University with a Bachelor's of Arts degree in history. If confirmed, Ms. Reardon would be a tremendous asset to the Southern District of New York, and I'm proud to recommend her to the bench.
Thank you, Senator Gillibrand, and thanks to my three colleagues. I want to acknowledge that Senator Peters injured his leg and is unable to personally attend, but wanted to make sure that on behalf of himself and Senator Stabenow, that he was here by WebEx. Are you still available, Gary, Senator Peters?
Yeah, I'm here, Chairman Durbin.
Please proceed.
Well, thank you, Chairman Durbin and Ranking Member Grassley. And on behalf of Senator Stabenow and myself, it's certainly an honor to once again introduce Judge Stephanie Dawkins Davis to this committee. Nearly 3 years ago, Senator Stabenow and I were very proud to work in a bipartisan way to recommend Judge Davis for the U.S. District Court for the Eastern District of Michigan. Back in 2019, the Senate voted to invoke cloture on her nomination by an overwhelming vote of 90-1. And the next day, her nomination was confirmed by a voice vote. Since then, Judge Davis has served Michigan and our nation with distinction. Today, we are proud to again recommend her, this time as President Biden's nominee, to serve on the U.S. Court of Appeals for the 6th District. I also want to recognize Judge Davis's family, who's with her today, her husband, Grant, her children, Kianoa, Maya, and Jay-Z, and her good friend, Sonya Thompson. It is crucial that in Michigan, as well as across the country, that we have a strong, independent judiciary committed to upholding our nation's laws and administrating justice. I'm confident that Judge Davis has the professional qualifications, the independence, and the fundamental sense of fairness and justice to make her, again, worthy of the Senate's favorable consideration. A born litigator, Judge Davis became interested in the law at a very early age. Inspired by the landmark Brown versus Board of Education case, I understand that even in kindergarten, Judge Davis had a reputation of resolving disputes among her classmates. Judge Davis began her career as a civil defense attorney and later joined the U.S. Attorney for the Eastern District of Michigan's office, prosecuting cases both at the trial and the appellate level. Her success led to the appointment as Executive Assistant U.S. Attorney, a position that she held for 5 years. In 2016, she was appointed a magistrate judge for the Eastern District, working in the federal courthouse in Flint. Since her Senate confirmations, Judge Davis has faithfully served as a district judge for the Eastern District of Michigan. Throughout her career, Judge Davis has been an exemplary public servant, working hard to serve the people of Michigan and earning the respect of her colleagues all across our state. Her commitment to community service extends beyond her professional work. I first met Judge Davis when she co-chaired the Detroit Youth Violence Prevention Initiative to help ensure that all children have a path toward a high quality of life through education and jobs and careers. She is and has always been dedicated to ensuring equal opportunity and equal justice under the law. I am proud to recognize Judge Davis today for her many professional accomplishments and for her diverse voice and perspective that she will bring to the Court of Appeals for the 6th Circuit. I thank this opportunity, Mr. Chairman, and I appreciate this time today.
Thanks, Senator Peters, and it'll be noted that you're speaking on behalf of yourself and Senator Stabenow, who raised this issue with me last night at the State of the Union, that she had a nominee coming before us today that she was very interested in. We next have Senator Padilla from California. Senator Feinstein would be here but for a family situation, which we're all grieving with her for the loss of her husband. But Senator Padilla, are you available?
I am. Thank you, Mr. Chair. Thank you, Ranking Member Grassley. And I too am sorry I can't be with you in person today, but proud to join virtually this morning to introduce Robert Huey as President Biden's nominee to serve on the U.S. District Court for the Southern District of California. I believe Mr. Huey today is joined by his wife, Michelle, his father, Lou, and other members of the family. You know, Mr. Huey's roots in California begin with his family's story. His grandfather immigrated to San Francisco from China in the 1930s, making his home there until he joined the U.S. Army. So service is certainly a key element of the family's legacy. Today, Mr. Huey is a resident of San Diego, where he has lived for nearly 20 years. He is a talented lawyer who continuously seeks out opportunities to promote justice. He earned his undergraduate degree from Calvin College and his JD from Yale Law School. His career includes 12 years of service as an assistant U.S. attorney for the Southern District of California. During that time, he investigated and prosecuted more than 600 district court cases and 24 appeals on matters ranging from public corruption to securities fraud to bank robberies and more. He spent 3 years, excuse me, he spent 3 years on an overseas detail where he helped to train international partners and allies on counterterrorism efforts. He also established at the outset of the COVID-19 pandemic a district-wide working group that combated pandemic-related fraud. So certainly a pioneer and a visionary in that regard as well. Mr. Huey has demonstrated his dedication to justice for all during his time in the private sector as well. In his early years as an associate, he volunteered to represent asylum seekers in immigration court, a very noble cause. In his current position at Jones Day, Mr. Huey coordinates the firm's pro bono legal work in the San Diego region. He also chairs the Diversity and Inclusion Committee for the office. So I believe Mr. Huey's commitment to service, his strong work ethic, his insightful legal thinking will benefit the community of the Southern District. And colleagues, I strongly urge you to support his speedy confirmation. Thank you, Mr. Chair.
Thank you, Senator Padilla. And of course, statement in support of Mr. Huey is also being entered into the record on behalf of Senator Feinstein. We have two panels. The first panel will be the Circuit Court nominees, Judge Davis and Ms. Freeman, if they would please approach the table and remain standing for a moment while we administer the oath. Do you affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that both Judge Davis and Ms. Freeman have answered in the affirmative. Judge Davis, I give you the floor and 5 minutes to say a few words about yourself, your family, and your aspirations in life.
Thank you, Chair Durbin. I'd like to start off by thanking the chair and ranking member Grassley for setting this matter for hearing this morning. I'd also like to thank each and every one of the committee members for setting aside time out of their schedules to hear from me this morning concerning the nomination. Additionally, I'd like to thank Senator Peters for that warm and generous introduction this morning, and I'd like to thank both he and Senator Stabenow for the strong support of my nomination. I am, of course, grateful to President Biden for making this nomination, and I would perhaps be remiss if I did not acknowledge U.S. Court of Appeals Judge Helene White, whose announcement of taking senior status caused the vacancy for which I have been nominated. I congratulate Judge White on her many years of committed service to the Sixth Circuit Court of Appeals. I do have here with me today my home team, members of my family, and my dear friend. I'll start off with my dear friend Sonya Thompson, who I met on my very first day of law school. We did a bit of reminiscing this morning. She is someone who stood up at my wedding, and I'm happy to have her stand here beside me here today. I have each of my 3 children, my oldest son, Keanoa Davis, my daughter, Maya Davis, and my youngest son, Jossie Davis, who've traveled from Michigan and Iowa to support me here today. And last but not least, I have the backbone of my family and the love of my life. My husband of nearly 30 years, Grant Davis, is here to support me also. In addition to those individuals in the room, I also have a host of family, friends, and colleagues who are watching remotely in support of my nomination. Chief among them is the woman who showed me that I could do all things and showed me how to be an independent person. That's my mom, Earlene Rowland, and my stepdad, Ronald Rowland, who are watching remotely from Kansas. My court family is also watching, all of the members of my chambers. So with that, I thank you for this opportunity, and I look forward to answering your questions.
Thanks very much, Judge Davis. Ms. Freeman?
Thank you, Chair Durbin, for welcoming me this morning. And I thank you and Ranking Member Grassley for convening this hearing and all the members of the committee for considering my nomination. I'm grateful to President Biden for the tremendous honor of this nomination. And I thank Senator Casey for his support and his kind introduction, and Senator Toomey for meeting with me during this process. I would not be here today but for the love and support of my amazing friends and family. My brother, Tulani Freeman, took a brief break from his job as a middle school vice principal in Washington State to travel here and be here today. My uncle, Gary Casangino, and my aunt, Denise Raish Casangino, have traveled from my childhood home state of New Hampshire to be here. And a dear friend from my adopted home state of Pennsylvania is joining me as well. My biggest supporter, my mother, Linda Casangino Freeman, could not be here today, but is watching this hearing from her home. She has retired after a 31-year career with the United States Navy, and she has always been a role model for the values of hard work and integrity. And I am so grateful for all the sacrifices she has made for me. My father, Thurman Freeman, passed away many years ago, but if he were here today, this would undoubtedly be one of his proudest days. I also appreciate the numerous additional family members, friends, and colleagues who are supporting me today and always. In particular, I want to acknowledge my federal defender colleagues and the judges for whom I clerked. I welcome the committee's questions.
Thank you both very much for being here. And again, let me extend my apology for coming in late for the session. We have a debate going on in this committee that started under the Biden administration. I can't recall, having been here a few years, that we had it before. And it's a question of whether or not we should have people who were public defenders serve on our federal bench, either at the appellate level or at the trial level. Some of us believe that we've had some extraordinarily talented young people, men and women, who have backgrounds as prosecutors who have served us well and continue to on the bench. Ms. Freeman, you're a classic example of someone who started off as a prosecutor and went into the magistrate position, comes before us today seeking this circuit court appointment. Judge Davis, Judge Davis is magistrate. I confused that. Ms. Freeman, background as public defender. And I'd like you, if you can, to comment for a moment if you bring any particular bias to the role of circuit court judge based on your previous professional experience. And perhaps you would like to at least refer to the case of Anthony Velasquez, which I think is a good illustration of your background.
Thank you, Chair Durbin. In my 12 and a half years of service as a federal public defender, I have represented indigent individuals regardless of any personal views that I might have about the case matter, because that was my duty to serve the court and to zealously advocate for their interests. I have fulfilled that duty as an advocate, and if confirmed, I would fulfill the very different duty of a judge, which is to fairly and neutrally apply the law to the facts at hand in each case. And thank you, Senator, for referring me to one of the matters that I handled along with a colleague in the Third Circuit Court of Appeals. That is a case to which the court appointed my office and to handle at the appellate level after he had been pro se in the district court. It involved a challenge to a state court conviction and an issue about whether certain procedural procedural requirements had been fulfilled. And the Third Circuit agreed that they had not. And because of that, the court ordered that a writ of habeas corpus should issue and that he should be entitled to a new trial. And that was all to protect the fundamental rights that the Constitution guarantees.
And I might add that the Third Circuit included 2 Republican appointees who agreed with your argument and granted the habeas relief sought by your client. They had specific praise for your advocacy. Judge Davis, your background when it comes to prosecution includes a case which had some application at the time and still does, U.S. versus Chiffinio. Would you like to tell the committee a little bit about that experience?
Certainly, and thank you for the question, Chair Durbin. United States versus Chiffinio was a case that was involving a very important issue that still confronts this nation today, and that is the issue of drug diversion involving opioids. In that case, there was a criminal conspiracy that was led by a doctor and a pharmacist, as well as other individuals who were running what in parlance is commonly referred to as a pill mill. I led the investigation of that case. I indicted the case. I prosecuted the case all the way through. 4 of the 5 defendants pleaded guilty. The 5th defendant opted to go to trial, but on the 2nd day of trial, after I think maybe 1 witness, he also pleaded guilty. And it was one of the first cases in the Eastern District in which we prosecuted a large-scale opioid dealer. Dr. Chiffinio had at that time been one of the highest level of prescriptions for these opioids in Michigan. And because of that, these drugs were not only going on the streets in and around Detroit and Michigan, but they were also going outside of the state.
I would just say, in closing my questioning here, that both of you bring extraordinary experience to this new pursuit in your careers, and I think bring the kind of personal and professional backgrounds which are important that the court see on a regular basis when they deliberate. I thank you both for being here today. Judge Grassley? Judge Grassley.
Okay. Sorry I missed your opening statements. I had a live radio Q&A I had to do at that time. I'm going to start with Judge Davis. During your confirmation hearing, you said that you were, that's when you were district judge, that you were neither an originalist or textualist. You also suggested that you do not have judicial philosophy. Now that you've served as a district judge and a magistrate judge, do you have a judicial philosophy or an approach to deciding cases?
Thank you for the Thank you for the question, Ranking Member Grassley. I would say that I still don't subscribe to any particular label, but I do recognize that depending on the type of case, there is Supreme Court precedent for the way in which a particular case should be analyzed. So, for instance, I'll start off by saying, with respect to textualists, I think it was Justice Kagan who said that we're essentially all textualists from the perspective that when you're looking at a statute or the Constitution, we start with the words that are on the paper, the text that is there. The Supreme Court has also indicated in certain areas looking at the original meaning is also important. For instance, in Heller, that is exactly what the Supreme Court said, and also in Crawford in dealing with confrontation clause issues. And so it's always my goal and intention to follow the precedent in terms of the way in which analysis should be undertaken.
Ms. Freeman, your career has focused heavily on habeas corpus, I've been informed. The Third Circuit has many cases involving corporate law, security litigation, antitrust, administrative law. And so I'm interested to know how you would handle other legal issues. Have you handled cases in any of those areas that I just described or areas that I didn't mention that you would probably think of? If not, can you tell us about your plan to become familiar with the areas of law besides habeas?
Thank you, Senator. In my 12.5 years of service as a federal public defender, I have frequently encountered a variety of legal issues. I represent individuals who are challenging convictions and sentences that occurred in state court as well as federal court. And so I often need to study state law, state procedures, as well as substantive and procedural federal law. So those skills I would use, if confirmed, to review a variety of matters on the Court of Appeals. Additionally, as a judicial law clerk for 2 years, I worked on all manner of civil cases, including many of the types of cases that you mentioned in your question, Senator.
Okay, another question for you. You were interviewed on something called Doing Time podcast. And during the podcast, I quote you, "There's really very little in the law that is clean-cut, and particularly constitutional law and federal statutes. There is vigorous debate over many of these issues. Oftentimes, I, meaning you, am 100% convinced that I'm right about how the law should be interpreted, and the prosecutors on the other side have the same level of confidence in their view, and we rely on the courts to end these disputes," end of quote. Do you think that you often disagreed over the meaning of federal law because of differences of judicial philosophy? And can you tell us what your judicial philosophy is and how you think about it should be interpreted? Law should be interpreted.
Thank you, Senator, for that question. In thinking back about the times in which opposing counsel and I have disagreed about matters of constitutional law, I think primarily it's because of our perspective as advocates for our particular clients. As an advocate for my client's interests, I, of course, need to make the arguments that would benefit the client, and I use the boundaries of the law to make those arguments. And as I mentioned in the quote you read, there are gray areas, and we do rely on courts to resolve those neutrally and fairly after considering the arguments of the parties. In terms of judicial philosophy, I through my practice and my service as a law clerk, I've observed a methodology that supports the fair administration of justice, and that is the rigorous study of the law, scrupulous review of the factual record, and open-minded consideration of the parties' arguments. And if confirmed, I would also use open-minded consideration of my colleagues' viewpoints.
Okay, thank you.
Thanks, Senator Grassley. Senator Whitehouse.
Thank you, Chairman. I just wanted to flag that Ms. Freeman's nomination raises again the question of blue slips, circuit court blue slips. And I wanted to flag that when the decision was made under the previous administration, I think by Leader McConnell, to take away circuit court blue slips, I warned over and over and over and over again what a mistake that was for this committee, that if we gave up circuit court blue slips, we would lose our voices in judicial selection. It would disrupt the advisory panels that have proven quite effective in many jurisdictions in narrowing the recommendations to our colleagues. And it would move our power and prerogatives from the Senate to the executive branch of government. So here we are again. I would say first that we simply cannot have a system in which when there's a Republican president, there's one set of rules, and when there's a Democratic president, there's a different set of rules. I appreciate the appeals to collegial sympathy that I have heard from colleagues who are now in this predicament. But it's hard to have much sympathy for those appeals because so many members on our side received no collegial sympathy whatsoever for their circuit nominees. In fact, we've heard our colleagues who actually went through that experience describe how they received negligible consultation or none at all in the mad rush to confirm judges who had been selected by big money donors. So the question of what is enough consultation, we had an answer to that. Enough consultation that the senator associated with that seat was satisfied. Now we don't have an answer to it, and we don't know what enough is, and it's always going to be debated, and there are no guidelines on the field, and there's no ref ultimately to call the fouls. So I hope we can find our way back to a resolution, but as I said again, we cannot have a situation in which Democratic presidents face one set of rules and Republicans a different set of rules. We need to set this in a way that it is lasting and cannot be disassembled under the pressure of big money donors who want to see certain people get onto the courts so that they can rule in their favor. So I'm really sorry we're at this juncture. It was a self-administered wound, a self-own by the Senate to go down this road. And finding our way back, I think, will be difficult. But I hope we can do it. I know that my colleague, Senator Kennedy, has said some thoughtful things about trying to find our way back. And perhaps there is a way, but that's the predicament we are in. And it was brought on us by a decision to disrupt that practice by our colleagues. Thank you.
Thank you, Senator Whitehouse. Senator Kennedy is next.
Thank you, Mr. Chairman. Judge, Counselor, congratulations. Counselor, in about 60 seconds, because I only have 5 minutes, could you tell me, in your opinion, what, if anything, is wrong with the criminal justice system in America?
Senator, thank you for that very broad and very important question.
You're welcome.
I understand that there are numerous issues involving the criminal justice system that are the matter of vigorous debate in the public.
Give me two. Give me two things that you think are wrong with our criminal justice system.
Senator, I truly respect the role of policymakers in considering questions like this. It involves so much study of empirical data.
Counselor, I understand that. But give me two things. Maybe you don't think anything's wrong with it, but if you could give me two things you think, in your opinion, are wrong with our criminal justice system.
Senator, in my 12 and a half years of practice in post-conviction law, I have observed instances where individuals were denied fundamental rights that were defined in the Bill of Rights. And I, in many cases, have been able to assist those individuals in seeking vindication.
Okay, let's move on, Counselor. Do you think it's appropriate for a prosecutor to decide not to prosecute certain classes or lines of criminal law violations in the name of social justice?
Senator, I have not had the opportunity to review the legality of challenges to an executive's
I'm not asking your opinion about the legality. Some of our DAs, you've read about them, I'm sure, in Philadelphia, Los Angeles, for example, other places, have said we are going to ignore criminal statutes passed by the legislature and not prosecute certain lines of cases in the interest of social justice. And I'm asking your opinion about that.
Senator, I do not actually have an opinion about that per se. I do recognize that constituents.
Counselor, you're an intelligent person. You spent your life in criminal, involved in criminal law. You don't have an opinion? Have you thought about it?
Senator, I'm not sure which specific instances of categories of crime that are not being prosecuted you're referring to.
Sure. How about shoplifting? How about receiving stolen property? How about resisting arrest? How about making criminal threats? Do you think those are all statutes, criminal violations? Do you think it's a very simple question, Counselor. Do you think prosecutors should decide in the name of social justice not to ignore these criminal violations? Have you thought about it?
Senator, I can't say I have.
You're telling me you've not given any thought to this?
Senator,
None whatsoever.
Thank you.
Counselor, I don't believe you. I'm sorry. I just don't believe you. You're a well-read, intelligent person. And I don't know why you won't give me your opinion on this.
Senator, I've focused on specific criminal cases as an advocate, as an appointed counsel.
I know that, but I'm asking your opinion. I'm going to ask it one more time. Do you think prosecutors should ignore criminal violations as per statutes passed by a legislative body in the name of social justice as a matter of class of cases?
All I can say, Senator, is I believe that prosecutors have a very important job.
I agree. Their job is enormously important. I'm just asking you to answer my question. I can't vote for you if you're not going to answer my question, because I don't know what position you're going to take if you're on the court.
Thank you, Senator.
Would you answer my question?
I would hope that prosecutors would use all of their tools and resources to make important decisions about issues such as the one that you've raised. And if confirmed, I would review the legality of any challenge.
Counselor, I'm very disappointed. I'm getting word salad here, and I don't even have dressing on it. We both know what I'm talking about. And I think your refusal to answer gives me the answer, with all due respect. Thank you, Mr. Chairman.
Thank you, Senator Kennedy. I'm going to comment on your question.
Well, I'm going to want to respond.
I want you to.
Okay.
Attorneys and prosecutors make decisions every single day as to what cases will be prosecuted and which cases will not. It is physically, legally impossible to prosecute all cases. They establish priorities. They try to serve the public in establishing those priorities. Every prosecutor makes that choice. They can't prosecute every possible violation of the law. That's just part of their responsibility. I don't see why that is a reflection on whether or not you agree with their choices or not. Some are going to take a much different view than others. That's just the nature of it. And in terms of summarizing what's wrong with the criminal justice system in 60 seconds, challenge any one of us to do the same.
Well, Mr. Chairman, you know, Dick, the affection that I have for you. But this is the third hearing in which you've made editorial comments about my questions.
But I'm leaving the floor open to you.
So I want to respond. Number one, this very bright person has spent her life in the criminal justice system. I don't think it's unreasonable to ask what, if anything, she thinks is wrong with it and get a candid answer. Number two, of course you're right about prosecutorial discretion, but you and I both know that's not what my question was about. We have a number of district attorneys that have taken the position that they are going to ignore criminal statutes passed by a legislative body, and they are not going to prosecute, they meaning the prosecutors, an entire line of cases, for example, shoplifting, receiving stolen property, resisting arrest in the name of social justice. Now, Mr. Chairman, we both know what I'm talking about, and so does the witness. And I don't know why she won't answer the question, and that's the point I was trying to make. I mean no disrespect to either of you, but I think my questions are perfectly appropriate in this environment.
Thank you, Senator. Anything more to add at this point? Okay, thank you very much. I believe that Senator Blumenthal is next.
I entered the room in the midst of your questioning, Senator Kennedy, so I can't attest to what the full line of questioning is, but let me just say as a former prosecutor, I believe laws should be enforced. They should be enforced rigorously and vigorously. A prosecutor saying that a particular statute just shouldn't be enforced across the board would strike me as wrong. But there is a great deal.
Would you like to be a federal judge?
But there is a great deal of discretion in enforcing individual case for all kinds of reasons that members of this panel are well aware. And I think to ask a general question about prosecution certainly is your prerogative, but I'm not sure what you expected this witness to answer, given that you didn't ask about a specific case or a specific statute.
That's fair, Senator. I expected a straight answer, and I didn't get one.
Well, let me just ask Ms. Freeman, you believe in law enforcement, don't you?
Yes, I do, Senator.
As a judge, would you make sure that the laws are faithfully and fairly enforced?
Yes, I would.
And you wouldn't favor one side or another?
I would not.
You wouldn't interfere with the judgments of the prosecutor to bring a particular case, assuming that there is a legal basis for it?
I would not, Senator.
And you have spent a good deal of time as a public defender, but I assume you recognize the legitimacy, in fact, the need for prosecutors to bring cases, enforce the law, seek penalties, and make sure that the law operates as a deterrent as well as a punishment.
Yes, I do.
I was a prosecutor for a long time, and including state attorney general, my state, and a federal prosecutor, U.S. attorney. I always felt that the most important decisions I made, and the most difficult ones, were whether or not to bring a case. Because all too often, that's the judgment the public makes about a person. They've been indicted, they've been charged, they must be guilty, even if they're later acquitted. So the standard that I used, and it was the Justice Department standard at the time, I suspect it still is, that you bring a case if there's evidence to show that someone is guilty beyond a reasonable doubt. And that is the kind of standard that I think should be enforced or followed in federal courts in terms of carrying the burden that the prosecution has, which is to prove guilt beyond a reasonable doubt. And if you don't have the evidence to do it, you shouldn't bring the case. Now, as a defender, you had an obligation as a defense counsel to provide a competent, effective defense, regardless of your particular liking or not about the client, the defendant whom you represented, correct?
That's correct, Senator.
That's the duty of a lawyer, isn't it?
It is.
And that's the duty that all of us have at one point or another had, because I've been a defense counsel too. And that's the way this system works, the contention, the crucible of presenting evidence. But as a federal judge, you're not on one side or the other, are you?
Absolutely not, Senator.
Thank you. Thanks, Mr. Chairman.
Thank you, Senator Blumenthal. Next up is Senator Blackburn.
Thank you, Mr. Chairman, and congratulations to each of you. We're pleased that you are here. Judge Davis, I want to come to you. I'd like to talk a little bit about the Priorities USA versus Nestle case. And I want to be sure I'm understanding this right. So, Priorities USA is a progressive organization, and they challenged Michigan election law that was aimed at preventing a kind of voter fraud that is known as vote hauling. Is that correct?
The Sixth Circuit found that that was the reason for that particular law.
Okay. So vote hauling can be a form of bribery, which is paying a voter to get to the polls and to get themselves and their family to the polls. And so you enjoined Michigan's enforcement of this law, correct?
Senator, I want to be, before I answer your question, I just want to be clear. Will be somewhat limited in how much I can comment on that particular case because it's still pending before me. But the short answer to your question is that I enjoined enforcement of that particular statute.
All right. You know, we've had a lot of discussion about election law, and we should make it easier to vote, and we should make it harder to cheat. So I would like for you to walk me through your understanding of the state's authority to regulate its own elections, as well as where are the limits on that authority?
Thank you, Senator, for the question. With respect to election law, the state has authority to regulate its elections. However, if during the course of that it burdens any constitutional right, then there is an analysis that has to be applied, and you look at what the level of burden on the right is. So if it is a minimal burden, then rational basis review will follow. If it is a heavy burden, an undue burden, then strict scrutiny will apply. And if it's something in between, then you apply the Anderson verdict test, where it's an intermediate level of review.
So was it your opinion that vote hauling should be allowed?
Senator, no. So
why did the circuit reverse you on that?
The issue of, and I'm just trying to be careful so that I'm not going outside of the bounds.
Right, and I appreciate that.
And the issue of vote hauling, as that term is used, was something that was argued before the Sixth Circuit. I was not familiar with that terminology before that.
Okay, so do you believe that the Constitution has the right to say to the state legislature, do you believe in the provision that states that a state legislature has the responsibility to set the time, place, and manner of election? Do you believe in that constitutional delegation to the states?
That's consistent with the law, yes.
All right. I want to talk to you a little bit about your judicial philosophy, your responses in written questions from Senator Booker when you were nominated for the district court. You said that you did not consider yourself to be a textualist or an originalist. So what is your judicial philosophy?
As I stated when I was speaking with Ranking Member Grassley, while I don't subscribe to a particular label, what I indicated is that the manner of analysis that I apply in any given case is based upon the precedent in that area. So, for instance, if there's a statute that I'm looking at, as Justice Kagan said, we're all textualists. We're going to start with the letters that are on the paper in front of us, and we are going to begin there. Next, we're going to look to precedent. We'll look to the structure of the structure and context of the actual statute, and so on. Additionally, the Supreme Court has stated in particular areas that there is an analysis that should be undertaken. So, for instance, in the area of Second Amendment, the Heller decision has said that original meaning is what you look to in interpreting the Second Amendment. Similarly, in Crawford, which involved the Confrontation Clause, that's also an area where original meaning is the manner of analysis. So I would always follow what the Supreme Court precedent says in terms of the manner of analysis that should be used.
Thank you. I appreciate that. My time has expired. Judge Freeman, I have some questions on incarceration in the prison system that I'll submit to you. Thank you.
Thanks, Senator Blackburn. Senator Coons.
Thank you, Chairman Durbin. I want to congratulate all of today's nominees across both panels, those who are nominees to the circuit courts and to the district courts. And I am incredibly proud, Mr. Chairman, of the nominees that have been sent to us by President Biden and this administration, qualified and thoughtful judicial candidates from an array of backgrounds. Ms. Freeman, I'm particularly happy that we're taking up your nomination today to the circuit of which I'm an admitted member and where I served as a judicial clerk on the Third Circuit, and a circuit that I know is home to excellent and collegial judges. The committee received a number of glowing statements of support for your nomination, which, Mr. Chairman, I don't think have been entered into the record yet. One of them from a longtime district court judge from the District of Delaware, Judge Gregory Sleet, now retired, and another from the Dean of the Delaware Law School. Have those been admitted? Then if I might, just for a moment, Judge Greg Sleet, he's someone who's been a pillar of our legal community in Delaware, serving as U.S. attorney and then as a judge on the district court, and 7 of those years as the chief judge of our district, one of the busiest district courts in America. And as he writes in his letter, which I'll admit for the record, if I might, without objection.
Without objection.
Thank you, sir. I'm well acquainted with the qualities and qualifications that make for a good federal judicial officer, and I believe Ms. Freeman's well qualified to serve on the Third Circuit Court of Appeals, and he urges your confirmation. Your Delaware fans also include Dean Rodney Smalla of the Delaware Law School, and he goes through in some detail in a letter that was joined by law school deans from Delaware, Pennsylvania, and New Jersey, the contributions that you will make, the way that you have dedicated your entire legal career to public service, and the significance of having a public defender and a former clerk on this court join the Third Circuit. We've already heard how your addition to this court will make history. You'll be the first black woman to serve as a judge on the Third Circuit. But I also think it's equally important that we have someone with the background you have, the legal service that you have. As I mentioned, the Third Circuit is known for being a collegial court, a thoughtful and rigorous court. Please tell us, if you would, how you'll draw on your career in the law and your life experiences to collaborate with your colleagues and to build relationships that will strengthen the circuit.
Thank you, Senator Coons. In my experience as a federal public defender, I've had the opportunity to appear before several members of the Third Circuit Court of Appeals, and I find them consistently thoughtful, inquisitive, attentive, prepared, and it would be my absolute honor to join them on the bench and to benefit from their perspectives. I would hope that my perspective of having litigated in numerous matters involving state court convictions and federal court convictions, as well as post-conviction procedure, the intricacies of 2254 and 2255 rules, and the application of the federal rules of civil procedure to those matters would all contribute to my consideration of matters that might come before the Third Circuit Court of Appeals.
And just to follow up on an issue I think that was implicitly being debated earlier, as a defense attorney, as someone who's practiced significantly as a defense attorney, have you ever argued that a particular crime should categorically not be prosecuted?
I have not, Senator.
And can you imagine that being a responsible or reasonable position that you might have advanced or advocated?
Senator, I have not seen any opportunity to make such an argument. All of my arguments are based on available avenues for relief for my clients within the rule of law.
Well, thank you, Ms. Freeman. Congratulations, Judge Davis, and I look forward to the swift confirmation of these qualified nominees. Thank you.
Thanks, Senator Coons. Senator Hawley.
Thank you, Mr. Chairman. Congratulations to the nominees. Thanks for being here. Ms. Freeman, if I could start with you, let's talk about Terrence Williams, if we could. This is someone who you represented in 1981. He committed a burglary. That next year, he committed armed robbery. He broke into the home of an elderly couple on Christmas Eve, I believe, woke them up by pressing a gun to their heads, fired that gun to threaten them into submission. Fortunately, nobody died in that incident, but as I'm sure you remember, others were not so fortunate. In 1984, while he was on release for that armed robbery, he murdered Herbert Hamilton by bludgeoning him with a bat and stabbing him 20 times with a 10-inch butcher's knife, and he then tried to set the body on fire. That is not, however, the murder for which he received the death penalty. 6 months later, he brutally murdered Amos Norwood. He drove this individual, the victim, to a cemetery, made him lie down near a tombstone, bludgeoned Mr. Norwood with a socket wrench and then a tire iron. Before using Mr. Norwood's credit cards to go on a shopping spree, he returned the next day and set Mr. Norwood's body on fire. The court record reflects that one of the motivations apparently for the crime was that Mr. Norwood was gay, and I haven't even listed all of his crimes. He was convicted by a jury of his peers. He was found to be eligible for the death penalty. He was sentenced to death, and then you intervened. And you argued for years that Pennsylvania law shouldn't be carried out, that he shouldn't be actually executed according to the laws of Pennsylvania. Numerous courts rejected the claims that you raised on behalf of this individual. Do you regret trying to prevent this individual who committed these heinous crimes from having justice served upon him?
Senator Hawley, my office was appointed to represent Mr. Williams for his post-conviction proceedings, and we did so as was our duty. And ultimately, Mr. Williams actually prevailed both in the United States Supreme Court as well as in the Pennsylvania courts because of unlawfulness that took place during the course of his conviction. And my colleagues and I pursued those available arguments under the law, and we did prevail.
Well, the death sentence was not carried out because of a technicality involving a justice on the Supreme Court, the Pennsylvania Supreme Court, who refused to recuse himself 30 years later. It has nothing to do with the facts of the case. So what I hear you saying is you stand by the arguments you made that this individual should not be executed, that this sort of person, under Pennsylvania law, he was convicted, he was sentenced to death, and you argued for years, long before the recusal issue and having nothing to do with that, you argued that on the facts of the case, this individual shouldn't be executed despite the fact it was Pennsylvania law. I take it from that you're opposed to the death penalty as a matter of principle.
Thank you, Senator. My office, again, was appointed to pursue Mr. Williams' constitutional rights. And we raised a number of constitutional challenges, some of which actually, in addition to the recusal issues, did ultimately prevail. There was a violation of due process that was found.
But you say that, Ms. Freeman, but you get to choose as an advocate. I've been an attorney. I am an attorney now, former prosecutor, the attorney general of my state. You get to choose the arguments that you make. You get to choose how you defend your client. You chose to defend this individual and to seek to have the sentence he was given, to have it prevented from being carried out upon him. And I'm just, in light of these facts, I'm amazed by it. I'm also amazed at what the Pennsylvania Supreme Court Justice had to say about your office, which you've now twice referenced. He said, and this was in one of the cases in which you were involved, this is the Chief Justice of the Pennsylvania Supreme Court. He says it has only recently emerged just how pervasive a presence your office, the Federal Community Defender's Office, has made itself in Pennsylvania capital cases, almost invariably without legitimate court appointment and without any Pennsylvania authorities' approval or role of oversight. This private group of federal lawyers pursuing an obstructionist, anti-death penalty agenda have essentially anointed themselves as statewide de facto capital defender's office. Common tactics of your office include multiple attempts to delay and obstruct cases like Mr. Williams, as well as attempts to unsettle and undermine Pennsylvania law. That's the Chief Justice of the Pennsylvania Supreme Court. Those are very serious allegations from the head of the court. If this is what your office was doing while you were there in these kind of cases involving people like Mr. Williams, how can we have any confidence that you will follow the law as a federal officer yourself?
I see that the time has expired. May I respond? Thank you, Senator Hawley. I understand that that was the position of the former Chief Justice of the Pennsylvania Supreme Court. I can tell you that I represent individuals when I have been directed to do so by the court, and I fulfill my duty to zealously advocate for those individuals.
So he was wrong. The Chief Justice was wrong. He misstated the facts or was incorrect here.
Senator, I'm not sure exactly which cases he was referring to in that quote.
This is a concurring opinion of the Terence Williams case.
Okay, I see. That was his opinion.
My time has expired, Mr. Chairman, and I'll have some additional questions for you, Ms. Freeman. All I can say is these allegations and this record, frankly, is extremely, extremely disturbing. And the idea that the Chief Justice of the Pennsylvania Supreme Court would talk about an obstructionist anti-death penalty agenda, attempts to unsettle and undermine Pennsylvania law, I suffice to say I have very serious concerns about your nomination. Thank you, Mr. Chairman.
Next up, Senator Booker.
Thank you, Mr. Chairman. Ms. Freeman, I just want to go back to that last exchange. Could you help me understand something? When you in particular, you're not speaking for your office here, but if you're in particular assigned a case and someone has a capital threat that they might be put to death, isn't it your solemn obligation to try to defend that client? I guess I was missing something there. That's your obligation, right?
Senator, it is my obligation as an attorney to zealously advocate for the interests of my clients. And yes, I must do so regardless of what the conviction is or what the sentence is in the case.
Do you believe fundamentally that no matter how horrific the crime accused, no matter how wretched we may view the behavior, that everyone within our criminal justice system deserves a zealous defense?
I do, Senator. Those are fundamental principles that are articulated in the Bill of Rights itself.
And I guess it's a stretch for me to think that somehow you fulfilling this fundamental ideal of our judicial system is somehow an indication even of your personal beliefs, because whatever you personally believe about a client or what you personally believe should about what they've done, you have a solemn obligation to defend them as vigorously as possible. Is that correct?
Yes, Senator.
And as a federal public defender, can I make generalities about the people that you defend, and maybe even to the whole office, not just you individually? Are these folks who are, would you say, are the margins of our society? Are they the indigent? Are they the people who have are drug addicted, or people that are poor? Is there some generalities you can make about people that need federal public defenders?
Senator, our clients are universally indigent. That is what qualifies them for the services of my office and offices similar to mine. We are appointed to those cases to help fulfill the ideal of the fair administration of justice to all people, regardless of ability to pay.
And so why do this work? I mean, sincerely, it's a question of all the people, all the things you could apply yourself to as a lawyer. Why put yourself in a position where you're representing people who often are despised by society, who are accused, who are condemned, people who are looked down upon for the vicious acts that they're accused of? Why put your career and dedicate yourself to such people where, as we just heard, where people could cast aspersions on you and malign you for your zealous counsel. Why would you make this choice for your career path?
Senator, I have always been committed to public service, and from the earliest days of our nation, we've recognized that fairness and accuracy are essential in criminal cases, and that processes must be provided so that we can get things right when prosecutions happen. I fully believe in those rights and those principles, and I'm happy to serve the public by providing legal services to indigent defendants.
You're not helping me here. I want to get a little deeper than that. Your public service is being a prosecutor. For career advancement, heck, if you want to be a judge in America, that's a much better pathway, obviously, if you look at our bench, to career success. Heck, we've had former prosecutors in New Jersey become governor, become around the country, become senators. Why represent the despised? Why represent the maligned? What is it about you that has made a decision that you are going to align yourself with the part of our justice system that is representing those people that folks just want to throw away and put in jail, who have done actions that often rise such contempt within our society? And frankly, what they're accused of is contemptible. Why? What is it about you that makes that decision and not go into another form of public service?
Senator, I know that the justice system works best when individuals on both sides have quality representation. I think there are fewer people who are interested in doing service as public defenders, and it's a very challenging job. I enjoy a challenge, an intellectual challenge, and also the service aspect of the work.
Well, you are a humble and modest person. My time has expired, but I know our criminal justice system well. And we have a criminal justice system that right now, as Brian Stevenson says, treats people better if they're rich and guilty than if they're poor and innocent. And it takes a special kind of person to dedicate themselves to those who have perhaps committed awful crimes, to dedicate themselves to the ideal that everyone, even the poor, even the abused, even the addicted, even those who have done wretched things, deserve representation. It takes someone who is committed to principles a lot higher than career advancement. And I think it is woefully unfortunate that in the United States of America, our judges do not reflect the fullness of legal experience and commitment when it comes to the fullness of our criminal justice system. I applaud you for the decisions you've made in your life. I applaud you as the spirit of everybody from Madison, who represented the British in the Boston Massacre, all the way up to people like my hero, Brian Stevenson. I thank you for your career thus far. I think that the bench needs you. I think that you will make a phenomenal judge and bring lived experience to the bench that is woefully lacking and long overdue. So I just celebrate you and I thank you, and forgive me, Mr. Chairman, for going over my time.
You're forgiven, and Senator Lee is next.
Thank you, Mr. Chairman. I agree that it's very important for everyone to have zealous advocates defending them, even when, especially when, you've got an unpopular client who's been accused of a heinous offense. Everyone needs zealous representation. I think there is a line that has to be drawn, though, between zealous representation and arguing things that are indefensible. Now, when Senator Hawley read the quote from you a few moments ago, the quote from Chief Justice Castile from the Pennsylvania Supreme Court, these are pretty legitimate concerns. It's a rare thing in my experience. And I've worked in civil litigation, I've been a prosecutor, and I've also been involved in criminal defense. It's a very rare thing for a judge to use words like describing a particular office as engaging in repeated attempts to unsettle and undermine the law. What I was perhaps even more troubled by was your response. If I understood you correctly, you said that was just his opinion. There is a difference between an individual expressing an opinion and a judge before whom you're appearing making these arguments. These are arguments that a judge makes when imposing sanctions. And ordinarily when I see a judge express things like this, it's a very rare moment, but it's almost always accompanying a finding that it's time to impose sanctions. So do you want to explain what you meant by when you said that was just his opinion?
Senator, I agree that the quote that Senator Hawley read was from that concurring opinion. I can't tell you what the foundation of that was. It was about my office, that Justice's opinion of my office writ large. I'm not.
But he wasn't making it in the abstract, was he? Not just in the abstract. He was making it in a particular context.
I understand from Senator Hawley that he was making it in the context of a concurring opinion in that appeal.
In that case in which you were involved as a lawyer.
That's correct, Senator Lee. I do not recall being involved in that particular appeal, however.
Now, Judge Castile cited two other cases where these tactics were apparently used by your office, and I'd like to know whether you were involved in either of those. Were you involved in Commonwealth versus Porter or Commonwealth versus Abdul Salam?
I was not.
And even if you weren't involved in either of those cases, you have made statements that appear to appeal to some of the same tactics. In a presentation you gave entitled, quote, Appeal to the Equities, this instruction was given, quote, argue anything and everything you can think of to get your client tolling, because if his claims are untimely, they'll be dead before they even begin. Do you want to clarify what you meant by that statement?
Senator, I don't recall that presentation or that statement. Okay.
Happy to follow up on this in writing and supply you with additional background if you'd like. Now, I want to follow up on another line of questions you got from Senator Kennedy. Senator Kennedy was asking you how you felt about someone having a policy of just not prosecuting certain crimes, certain entire categories of criminal offenses in pursuit of a social justice objective. You didn't answer that. I'm still trying to understand why. I understand that prosecutorial discretion is a thing. It's an important thing. It's a thing that represents the fact that in any prosecutor's office, there are finite resources. You can't go after everything all the time, so you have to go after the cases that you can handle and handle that effectively. But that very same purpose is not only not served, it's actively undermined if a prosecutor says, I will not be prosecuting offenses A through G. I just won't be prosecuting them. Your refusal to answer that question and provide an answer like that is troubling to me. Do you want to explain why you're not willing to answer that one?
Senator, I recognize that the decisions that prosecutors make are complex policy decisions. I do not have all of the information relevant to those decisions, and I would rely on prosecutors to make appropriate decisions about the use of their prosecutorial discretion, and any legal challenges to that I would certainly review. But again, I do not feel informed enough to have a view on that question.
Yeah, but typically, and in fact, I could modify that by saying universally, legal challenges to a prosecutor's refusal to bring a case aren't really a thing. It's not how the system works. It's not You don't bring the case about the dog that didn't bark, and you also don't bring the case against the prosecutor who didn't bring a case. It doesn't mean that there aren't important questions of discretion, and it isn't prosecutorial discretion when you notify people in advance before they've even committed the crime that those crimes won't be prosecuted. And so of all the questions you've been asked today, this one strikes me as one that should have been the easiest to answer, and that's why I'm so perplexed by it. I'm not sure that I've encountered another nominee before this committee who has been unwilling to answer a question like that. It seems like the easiest question of all to say, yeah, a prosecutor should not categorically announce that he or she will never prosecute an offense in this category on the basis of a social justice concern. Can you help me understand that?
Yes, Senator. And in my career as an advocate, I have focused on specific challenges in specific cases, and if confirmed, I would focus on specific challenges in specific cases, and I am required as a judicial nominee to refrain from comment on matters of public policy, such as the one that you've raised. I understand those are issues of grave importance, and I defer to policymakers to make those decisions.
Hiding behind the canons isn't appropriate here. Isn't requiring you to comment on a particular case. I have grave concerns with your refusal to answer that. Thank you.
Thank you, Senator Lee, and Senator Ossoff is next.
Thank you, Mr. Chairman, and congratulations to you both for your nominations. Judge Davis, Ms. Freeman, should you be confirmed, will you faithfully apply the law without bias, without regard for your personal private policy preferences, according to your best understanding of the will of the U.S. Congress and judicial precedent?
I will, Senator.
Yes, Senator.
I'd like to ask you both about, based on your experience, your views on language access in federal courts and as well as other courts across the country. Ms. Freeman, based upon your experience as a public defender, what's been your experience of the particular challenges faced by parties trying to navigate the legal system who may not be fluent in English?
Senator, I understand that it actually may be a little bit easier in the criminal law context, and also because there is a right to interpretation services that my office regularly uses when we have clients who are non-English speakers, and I understand that the challenges may be different in civil cases where there is not that right to the provision of interpretation services.
Thank you, Ms. Freeman. And Judge Davis, based upon your experience as district court judge who routinely hears parties and witnesses providing testimony and arguments in your courtroom, what's been your experience either specifically at the district or across your legal career of the challenges faced by parties to litigation or in criminal proceedings for whom English is not their first language?
My experience in the Eastern District of Michigan has been very similar to Ms. Freeman's. In criminal cases, there is a right to have an interpreter present. Sitting as a magistrate judge and now as a district judge, I have presided over cases in which interpreters have been present. It's not quite the same in civil cases. I haven't had the issue come up in civil cases, but what I can say is that the court in the Eastern District has conducted outreach in communities where English is a second language to ensure that there is access to justice, particularly with respect to jury service and encouraging people who don't have English as their first language to participate in jury service.
Thank you, Judge. Ms. Freeman, it's been brought to my attention that the Third Circuit, the court to which you've been nominated, has praised you explicitly for your advocacy, the quality of your advocacy, and for your legal acumen. You have dedicated much of your career to representing indigent clients in habeas cases. Can you please characterize for the committee your experience in habeas cases, your perspective on relevant law and jurisprudence?
Thank you, Senator. I represent individuals whose convictions took place in both state courts and federal court. I represent individuals in the United States District Court as well as the Third Circuit Court of Appeals. My office gets appointed at different stages. In the district court, sometimes we are appointed so early that we have the opportunity to fully review the record, a voluminous record of what transpired in state court, for instance, to assess whether there were any constitutional violations that could be challenged in federal court under the governing law. We oftentimes compile evidence, present evidence to the district court, either documentary evidence or testimonial evidence, do briefing, oral arguments, evidentiary hearings in the district court. In the appellate matters, of course, there is a fixed record, but I have litigated 28 appeals in the Third Circuit, either alone or with co-counsel, and provided oral argument to the court on 7 occasions, including once to the en banc court.
Thank you. And question for you both, beginning with you, please, Judge Davis. At the appellate level, you may encounter more cases where you are called upon to consider novel legal questions or to reconcile conflicting precedent. How will you approach those challenges based upon your experience in the courtroom?
Thank you for the question, Senator. Depending on the type of question that is before me, if it is a novel question involving a statute, for instance, then I will engage in the tools that are available for statutory interpretation, starting first of all with the text. If the text is clear and unambiguous, then really the analysis ends there. If there is any ambiguity, and this actually is a novel question, meaning that it hasn't been dealt with in my circuit at all, then I would look to Supreme Court precedent. I think that your premise is that there is no Supreme Court precedent. So I'd also look for persuasive authority from outside of my circuit, look to how similar provisions have been interpreted, and use the canons of construction.
Thank you, Judge Davis. And with my brief remaining time, Ms. Freeman, the same question for you, please.
Thank you, Senator. It's hard to improve upon the answer that Judge Davis just gave. But I would agree that those are the principles that must be applied. You start with the text and with precedent from the Supreme Court and the relevant circuit. And if that is unclear, then you move on to the subsequent sources of authority, including the canons of interpretation.
Thank you, Ms. Freeman. Thank you, Mr. Chairman.
Senator Ossoff, thank you very much, and Senator Cruz.
Thank you, Mr. Chairman. Ms. Freeman, you disagree with the death penalty, don't you?
Senator, I support the rule of law, and if confirmed, I would apply the rule.
Ms. Freeman, that was not the question I asked you. You disagree with the death penalty, don't you?
Senator, if confirmed, I would apply the law regardless of any views that I may or may not have.
So you're hesitating because you're afraid to answer honestly.
Senator, respectfully, my understanding of the code of conduct for United States judges, which applies to judicial nominees, is that I am to refrain from commenting on matters of public policy that may come before me.
Really, this is the same person who submitted a photograph of yourself at a protest at the Philadelphia International Airport, labeled Ariana Freeman, Senator of Philadelphia, cheers and chants with others during a protest to President Donald Trump's executive order banning travel to the U.S. by citizens of Iraq, Iran, Sudan, Libya, Somalia, and Yemen. That's refraining from engaging in public policy?
Senator, I attended that public event in 2017, long before I was a judicial nominee and subject to the code.
Okay, well, the canons don't prohibit you sharing what your views are to this committee, and we have judges appear here all the time. It's not remotely credible that you don't have a view on the death penalty. You've devoted your entire professional career to representing criminals, to representing murderers, to representing rapists, to representing child molesters. You believe the death penalty is wrong. You have been a zealot against the death penalty. Is that true or false?
Senator, I have spent 12 and a half years fulfilling my duty to zealously advocate for the interests of my client, regardless of the sentence. Some of those sentences were death sentences. For the past 8 or so years, I have worked on non-capital cases.
Okay, well, I'll tell you, let's take the case that the Pennsylvania Supreme Court talked about, and Senator Hawley discussed this some. Terrence Williams, one of your clients, had a long list of violent crimes, including armed robbery and another murder, just months before he killed Mr. Amos Norwood. Mr. Williams had separately been convicted of murdering a different victim by stabbing him 20 times in the head, the back, the chest, clean through his neck, before then trying to burn his body. Apparently, this method of murder was one Mr. Williams was fond of, because his second victim, Amos Norwood, he blackmailed him to meet him in a cemetery, where Williams beat Norwood with a tire iron until he died. And then the next night, Williams returned to burn the victim's body. Terrence Williams is a bad guy. When you're faced with a repeat murderer about whom there are no serious questions of guilt, nobody doubts that this guy is a serial murderer, your choice, you don't feel sympathy for the victims, you don't stand with the victims. Your choice, you've spent your life trying to save that murderer. And listen, here's what the Chief Justice of the Pennsylvania Supreme Court said about your office. Because you keep saying zealously represent, and you're right, everyone is entitled to a defense. But it's not the job of a lawyer to be obstructionist. Is it the job of a lawyer to be obstructionist?
No, Senator.
Well, the Chief Justice of the Pennsylvania Supreme Court describes your office, says the extraordinary shadow capacity of the FCDO, your office, and its demonstrated tactics give me additional pause. Here the Chief Justice continues. Almost invariably without legitimate court appointment, without any Pennsylvania authorities' approval or role of oversight, this private group of federal lawyers pursuing an obstructionist anti-death penalty agenda have essentially anointed themselves a statewide de facto capital defender's office. Common tactics of the FCDO include multiple attempts to delay and obstruct cases, as well as attempts to unsettle and undermine Pennsylvania law. Do you think it's extraordinary that the Chief Justice of the Pennsylvania Supreme Court accuses you and your office of being zealots engaged in an obstructionist anti-death penalty agenda?
I'm not aware of how often something like that occurs, Senator.
Well, I'll tell you, I've practiced law a lot of years. This is extraordinary. And you know, Senator Booker asked, why do you choose to do this? I actually think Senator Booker's question was a great question. You said you care about public service. He rightly pointed out, well, you could have been a prosecutor. Many of us on both sides of the aisle have been prosecutors. You didn't want to be a prosecutor. You wanted to stand with the criminals because, as the Chief Justice has said, your office is engaged in a zealotry, in an agenda against the death penalty, game playing. And, you know, Senator Booker said, well, it's bad for your career to be a public defender. That actually is not the case. If you look at Joe Biden, last night Joe Biden said we shouldn't abolish the police, and all the Democrats stood and applauded. But interestingly enough, Joe Biden keeps nominating some of the leading advocates for abolishing the police to senior positions in the Department of Justice, and every Senate Democrat confirms them. Joe Biden keeps nominating DAs who refuse to prosecute violent crime to be federal prosecutors, and every Democrat votes to confirm them. And Ms. Freeman, you should feel comfortable. No matter how much your office has been called out for being anti-death penalty zealots, siding with capital murderers and ignoring the law, every Democrat on this committee is going to vote to confirm you. But I will tell you, this is a three-pronged strategy from the Democrats to abolish the police. Putting prosecutors in place who don't follow the law, putting judges in place who don't follow the law. And there's a reason we see crime rates and murder rates and carjacking rates skyrocketing across this country. Because the job of a judge is to follow the law, not to be a zealot pursuing a political agenda.
Senator's time has expired. I want to thank this panel for appearing before the Senate Judiciary Committee today. There may be written questions coming your way, which we hope you can respond to in a timely manner. We thank you and your families for attending this session. And now we're going to call the second panel. Thank you very much.
Thank you, Senator.
If you'd remain standing for just a moment. I'd like to administer the oath. If you please raise your right hand. You affirm the testimony you're about to give before this subcommittee be the truth, the whole truth, and nothing but the truth, so help you God. Let the record reflect that the three witnesses have answered in the affirmative. And we'll start with Mr. Huey and give each 5 minutes to say a few words about themselves, their families, and their aspirations. Mr. Huey.
Thank you, Chair Durbin. And my thanks to Ranking Member Grassley and to all the members of this committee for holding this hearing today. I want to especially thank Senator Feinstein and Senator Padilla for recommending my candidacy. And my thanks to Senator Padilla for his very kind words of introduction today. I want to express my deepest gratitude to President Biden for nominating me. It is deeply humbling to be nominated among such exceptional candidates. I'm here today because of the efforts and the kindness of so many others. I want to start with my mother and father, Jan and Lou. My father is here in the room today, and my mother is watching from home in Colorado. They have been role models to me through their example of kindness, of hard work, and of public service. My father served in the U.S. Marine Corps in the Vietnam War, where he earned a Purple Heart. Both of my parents devoted their careers to the U.S. Department of Defense. When I was a boy, I understood that what was most important to them about what they were doing was that they were serving the public. I'm also here today with my wife, Michelle. We met in college, and we were married over 23 years ago. For my entire adult life, Michelle has been my partner and my best friend. She's my inspiration and my hero. I'm happy to have my aunt, Juanita Huey Fuller, with me today from Missouri, along with my mother-in-law, Faith Limmer, and her husband, the Reverend Donald Limmer, from Illinois. I also want to mention my brother Jonathan and his wife Danielle, who were married 4 days ago, my uncle, Mike Fuller, and my father-in-law, Dennis Risney, both of whom were very dear to me, and my brother and sister-in-law, Rob and Heather Risney of Tennessee. Professionally, I want to especially thank Judge Cabranes, for whom I clerked, and my law school professor, Kate Stith, and my friends at Jones Day, General Electric, the U.S. Attorney's Office, and among the San Diego Criminal Defense Bar and the rest of the federal family. Each of you has enriched my life and has helped prepare me to serve with humility if confirmed. Thank you, Chair Durbin.
Thank you. Ms. Payden.
Good afternoon, Chairman Durkin. Members of the committee, I wish to express my gratitude for being here today. I would like to thank President Biden for this humbling nomination. I would also like to thank my home state senators, Bob Menendez and Cory Booker, for recommending me to the president. I deeply appreciate Senator Menendez's kind introductory words. I sit here before you as the first person in my family to have graduated from law school. I am the proud daughter of Puerto Rican parents who migrated to this country with very little money, seeking hope, opportunity, and the American dream. My mother cannot be here with us today as she is acutely ill. She came to New Jersey as a young woman, not knowing how to speak English. As an adult, she worked as a seamstress, went to school at night, and obtained her bachelor's and master's degree in social work. It is from her that I learned the lessons of humility and compassion. My father is with us here in spirit. He passed away 7 years ago. He was the driving force in my life and inspired me to be an attorney. He was a businessman who owned a travel and insurance agency for over 50 years in Jersey City. I would be remiss if I did not thank my parents. They instilled in me the value of hard work, respect for the rule of law, and the call of service to others. They have been my North Star and have instilled in me how to live a life of integrity and purpose. I would be remiss if I did not thank my extended family, friends, and colleagues from my home state of New Jersey. I thank Dean Buzang of the Seton Hall Law School, the New Jersey State Bar Association, the Hudson County Bar Association, and the Hispanic Bar Association of New Jersey, all who have supported me in this journey. To those present who are here with me today, attorney and former New Jersey State Bar Association President Thomas Pearl, immediate past president of the Hudson County Bar Association, attorney Francis Nicotra, my dear friends of over 25 years, attorneys and Seton Hall Law School sisters, Kelly Waters and Carmen Mendiola. You have all been my bedrock of support during this process. I would also like to thank and introduce my beautiful and smart daughter, Sophia Rose, who is 13 years old and a 7th grade student at Holy Trinity School. I could not be prouder of her. For 30 years, I have sought to uphold the Constitution and the rule of law in service to my clients. It would be an honor of a lifetime to serve my country as a federal district court judge, and as the judge's oath of office says, to administer justice and to do equal right by all. Thank you to the committee, and I welcome your questions.
Thank you very much. Ms. Reardon?
Thank you, Chair Durbin.
Turn the microphone on. There you go.
Thank you, Chair Durbin. Thank you also to Ranking Member Grassley and to all members of this committee. I am honored to be here. I would like to thank President Biden for nominating me, Senator Gillibrand for her kind introduction and her support, and Leader Schumer for his support. I'm pleased to be joined today by 4 family members, all of whom have sustained and inspired me. First, my mom and dad, Sandra and Jack Reardon, whose contributions and love have been immeasurable. They deeply value learning. They have been dedicated public servants, and, as shown by their close daily review and lively discussion of happenings in America, they love this country. The sunshine of our family, my sister, Sandra Parker, is here as well. Sand is a psychiatric social worker at a not-for-profit hospital in New York. She is an excellent listener, and she always believes that the best is yet to come. My bright, sporty, exuberant 11-year-old, Hutchison, whom I'm raising on my own, is also here. Hutch is my greatest joy, and he keeps me on my toes. Unfortunately, my brother John could not attend. John diligently works 2 jobs. Today, he is carrying out his food prep responsibilities at a public school cafeteria. Stoical John never complains, and he never gives up. I am also thinking of my grandfather, John Reardon, an obstetrician who joined the Navy the day after the attack on Pearl Harbor, quickly transitioned to combat medicine, and became the chief medical officer of the USS Telfair in the Pacific. 5 years later, he finally returned home and started all over again. And my grandfather, Rudolph Damiani, who grew up struggling to learn English, overcame polio,
also became a doctor and regularly accepted tomatoes and other homegrown vegetables from patients who were unable to pay. Since law school, serving as a federal judge has been my professional dream. If confirmed, I will work hard every day to uphold the highest standards and traditions of the federal bench. Thank you again, Chair Durbin and members of the committee. I look forward to answering your questions.
Thanks, Ms. Reardon. Ms. Padilla, I'm going to start with you. I have two questions. What did you do to become the first Latina elected head of the New Jersey Bar Association? And after you got the job, what did you do with it?
Thank you for that question, Chairman Durbin. The New Jersey Bar Association is a professional organization of over 18,000 attorneys. I represented them zealously through policies that the Bar Association formulated. I instituted a statewide law day while I was president of the New Jersey State Bar Association, where we offered economically disadvantaged people free legal services. Oftentimes, it was in high school gyms, and there was a team of attorneys who went there, and we provided legal consultation to economically disadvantaged people, landlord-tenant issues, criminal law issues, family law issues. That was one of the bedrocks that I'm quite proud of having done as the State Bar Association president.
So you think the right to counsel in the Sixth Amendment is something that we should honor?
There is absolutely no doubt. It's the Supreme Court state on point of Gideon.
Ms. Reardon, you had a significant case that you took on pro bono in 2009 involving a domestic worker who sued her employer, a married couple, for unpaid wages, and sued the husband for assault and battery. The case was referred to your firm from the Urban Justice Center, which incidentally, and this leaves them in a suspect category, that is where Senator Cory Booker first worked after he graduated from law school. You were the lead counsel for the domestic worker at trial. Would you explain what that case was all about?
Thank you, Chair Durbin. It was a privilege to represent Ms. Francois, a hardworking domestic caregiver who was extremely devoted to her young charge. I first chaired the trial on behalf of Ms. Francois. It was, as I think you mentioned, a jury trial in the Southern District of New York. It lasted several days. In my capacity as first chair, I delivered the opening and the closing. I directed and cross-examined several witnesses, and I briefed and argued numerous motions. I was also able to provide younger members of the team with stand-up courtroom experience. And we were gratified with the verdict, the district court judgments, and district court's judgment and the affirmance by the Second Circuit.
I understand the case involved violations of both federal and state fair labor statutes, along with state court claims.
That's right.
A little more complicated than the fact pattern that I described.
It's true, Chair Durbin, that the case centered on the federal and state wage and hour claims under the Fair Labor Standards Act and the New York labor law, and then there were several tort claims.
Thanks. Mr. Huey, you're a former assistant U.S. attorney, and you are now involved in private practice, but also active in pro bono work with the firm. Is that correct?
Yes, Senator, that's correct.
Sounds like you've sat at both tables in the courtroom from time to time.
Chair Durbin, that's correct.
Well, that's perfect for this committee because there are some who want to tip the scales one direction and some want to tip it the other. Turns out you can be found on both corners. I thank you for that. Tell me about the pro bono side of your life now.
Chair Durbin, thank you for the question and for summarizing my experience. The pro bono side of my life involves working mostly on immigration matters and on matters for victims of human trafficking, both of which are firm-wide efforts that my firm supports, and they're matters that I care deeply about.
And this committee does as well. I thank you. Senator Kennedy?
Thank you, Mr. Chairman. Councilors, congratulations. Mr. Huey, can you explain the holding in Roe v. Wade to me?
Senator Kennedy, thank you for the question.
You're welcome.
Roe versus Wade was a 1973 decision of the Supreme Court that recognized a right to an abortion.
Right. Can you explain the trimester test to me?
Certainly. There was a 3-trimester test that was then superseded by the Supreme Court's opinion in Planned Parenthood versus Casey. But the essence of the test was that for the first 2 trimesters, prior to the assessment of viability in that case, the woman's right to an abortion overrode the state's interests, such that courts would scrutinize any regulations that limited that right.
Okay.
In the 3rd trimester, that balancing would shift, such that the state's interests were greater in that context.
Okay, thank you. Ms. Padilla, did I say your name right?
Yes, Senator.
What's the difference between a summary judgment and a motion to dismiss for failure to state a claim on which relief can be granted?
A summary judgment motion is a motion that's filed because there are no issues of fact and it's only an issue of law that a judge disposes the motion on. The second part.
A 12B6, failure to state a claim on which relief can be granted?
A 12B6, it's a motion to dismiss. It could be for a variety of issues. It could be because they haven't met jurisdictional grounds.
Okay, thank you.
Thank
I
you.
appreciate you getting to the point, all 3 of you. Ms. Rudin, what's the Chevron doctrine?
Senator, the Chevron doctrine relates to the extent to which the judiciary will defer to an administrative agency's interpretation of a statute.
Okay, great, thank you. Mr. Huey. I'd like to ask your opinion on something. We have a number of prosecutors who have chosen in the name of social justice not to prosecute an entire class of cases, despite the fact that their legislature has passed these criminal statutes. Do you think that's proper?
Senator Kennedy, I think I can speak to that issue very broadly in the federal context, based on my experience as a prosecutor.
I'm asking just in both contexts, state and federal. I'm asking your opinion on this conduct by some prosecutors.
Well, to phrase my opinion in constitutional terms, on the federal side, Article 2 directs that the president shall take care that the laws are faithfully executed.
Right.
It's long been recognized that there's a principle of prosecutorial discretion.
Let me stop you because I'm going to run out of time, as I think you're aware. Do you agree with what these prosecutors are doing, or do you disagree?
Senator, I agree with the principle of prosecutorial discretion exercised in the interests of the United States.
That's not what I'm asking, and we both know that, Counselor. Do you agree with what these prosecutors are doing, or do you disagree?
Senator, I would have to get a little more detail in order to opine on that.
Are you afraid to give me an answer?
Certainly not, and I'm happy to give you an answer.
Okay, could you give me an answer, Ms. Padilla? Do you agree with these prosecutors, or as I described their conduct, or you disagree?
Thank you for that question, Senator. One would have to look at the position that the prosecutor is taking and why
I just explained it. Well, some prosecutors have taken the position, despite the fact that their legislature has passed a criminal statute, that they're not going to prosecute cases in violation of that statute. Do you agree with that or disagree with that?
Senator, I can tell you that if a criminal matter appears before me, I would apply.
I know you would, but I'm asking you your opinion on that prosecutorial decision.
But that's an area that really falls within the executive part of government.
Are you
to
afraid
be able
to give
to
me
address.
an answer?
No, but I think it's a complicated answer.
No, it's not. Do you agree or disagree?
Senator, once again, I'm going to say that it's within discretion of a prosecutor whether to prosecute or not. The voters.
Gordon, will you give me an answer?
Senator, I am aware that prosecutors must act consistent with the 14th Amendment. That comes up in connection with selective prosecution.
Yes, ma'am. But do you agree with the prosecutors or disagree?
Senator, I do not, sitting here today, have an opinion on that. It's outside my practice, and it is.
Have you thought about it?
It's not anything that I have studied.
Are you aware of the issue?
I am aware of the issue.
And do you agree with the prosecutors or disagree?
Senator, I can tell you that I am aware this is hotly debated in the mainstream,
Yes, ma'am.
and
I'm asking your opinion.
Legislators, I know there are positions on both sides. I have not refined an opinion on that.
Are you afraid to give me your answer?
No, Senator, I would give you an answer if I had it, and I'm doing my best to answer your question, but I do not.
You could have fooled me, Counselor. We both know what we're talking about here. I'm just at a loss why none of the three of you will give me an answer. It's very simple. Do you agree with the prosecutors or disagree? Are you going to give me an answer? I think I got my answer. Thank you, Mr. Chairman.
Senator Booker.
Thank you very much, Mr. Chairman. Ms. Padilla, real quick, if you don't mind, I just want to clear the air about two issues I have with you. The first of all, you went to both undergraduate and law school at Rutgers and Seton Hall in New Jersey. I went for my undergraduate law degree outside of New Jersey. You were born in New Jersey. I was born in Washington, D.C. My first question is, do you think you're more Jersey than I am?
I can tell you I'm a real Jersey girl, Senator.
I'm a little upset about that. And then the second thing to clear the air, you were president of the New Jersey Bar Association. You stood for and worked for greater access to justice. You made a statewide name for yourself, first Latina ever in that job as president. I failed to be a president when I tried. Are you more presidential than me?
Senator, I can tell you, being the State Bar Association president, the 120-year history was the greatest professional honor of my life. To accomplish that, the daughter of parents who came to this country who did not speak English. I worked very hard, and I attended Rutgers in New Brunswick and Seton Hall Law School in Newark, and I applied myself, and I consider myself to be the product of that American dream in this country. Thank you for that question.
Well, you are more Jersey than me, more presidential than me, and you will definitely be more judicious than me. I am so proud of you, and the state of New Jersey is. You have been an extraordinary public servant in every step of your career. You've made the judicial system in our state more just, and I'm just going to be honored to vote for you on the floor of the United States Senate, and I'm grateful for you. Mr. Chairman, I've cleared the air. I am done with my questioning. Thank you.
Thank you, Senator Booker, and let me thank the panel, and I would just make another editorial opinion statement before he leaves. Senator Kennedy, I think this three-member panel has done better on the Kennedy mini bar exam than many in the past. Though you may not be satisfied with all their answers, I'm glad you're not asking senators basic questions to define cases. Thank you for that. Thank you all for being here. You may get some written questions if they come your way and you can respond quickly and completely. It will move the process along. And since there's no further business come before the Judiciary Committee, again, I want to extend my apology for being a few minutes late this morning, but I think we covered a lot of ground. Thank you all for being here. The Senate Judiciary Committee stands adjourned.